Okay, thank you very much. Good evening, everyone. Thank you to be with us. So today is the special IP workshop, and of course is related to the voltage programs grant. And I am very happy today that we introduce two speakers, but myself right now I just explained about success story on the IP and so on. But the presentation one first by Beatrice Ngatcha. Beatrice she is a lawyer and patent agent on intellectual properties group of Lavery. She is registered as patent agent in Canada and United States, and also lawyer admitted in Ontario Bar as a member of Quebec Bar. Beatrice holds PhD in chemistry from Laval University and was postdoctoral fellow at National Research Council in Ottawa. In addition, she frequently practiced drafting and obtaining patent in Canadian international client. Beatrice's expertise is applied in the field of intellectual property litigations, trade secret, transaction and due diligence, patent-related business strategy, development, and the patent portfolio, value creation, licensing, and arbitration. And the second speaker, I'm going to just finalize the introductions, and then Beatrice will start. And the second speaker is Simon Carignan. Simon holds a bachelor's degree in electrical engineering with 32 years research working in Hydro-Québec, including 25 years specialist in intellectual properties management, and he has extensive expertise helping inventors protect their invention and the licensed technologies. So Beatrice, I will start with you. Please welcome.
So this is the agenda for today. So we are here from 1 to 2:30.
Okay, so hello everyone here in the room and also online. It's a great pleasure and honor for me to be here today. And so I'm going to share with you some thoughts regarding intellectual property, particularly patents, because I'm sure people here are mostly patent-related people. The type of research you do lends itself mostly to the form of intellectual property called patent. But before we launch into talking about patent, I thought I should really just give you another view of what's intellectual property, what are the forms of intellectual property, because it comes in many forms. And as we will see with an example that I've prepared for you, usually a technology is protected by a combination of more than two forms of intellectual property. So just briefly, okay, and I know Simon's going to touch on this as well. So patents, okay, we'll talk about it later. Just to mention that its term is 20 years from the date to file patent application, okay? So it's a limited protection. Industrial design is a limited protection as well, and it's the form of IP that protects the visual of innovation. So innovation lies in really like the visual that you have created for the product, but also the way the thing looks. And its term is up to 15 years. Trademarks, these are what surrounds us every day, the words, the terms that we use in association with some wares, some services. And today, it's not just word and logos as it used to be. There are so many things protected by trademarks these days, like holograms, like scent, like texture, even sound, so many things. And this is the form of IP that really lasts a long time. So its term is 10 years, okay? And if you keep renewing, it's indefinite. So you keep just paying your fees at the trademark office, and the term will just go every 10 years, it's continuous, indefinitely. And then copyright. So this is the form of IP that will protect books, pens, lyrics, and its term is the entire life of the person who has created the work, plus 70 years after they're dead. Okay, it used to be 50 and it's recently changed to 70. So it's a long term. Entire life of the creator plus 70 years after they are dead. And the next one, the plant breeder's right. This is the form of IP that protects new plant variety. Okay, its term is like up to 20 or 20 years, depending whether it's a tree or depending on the species. Okay? And then trade secrets, it's a form of IP as well. Okay, sometimes people are not sure, but yeah, trade secrets are a form of IP. So it protects confidential information. And its term is indefinite, can be protected indefinitely as long as you are able to keep it secret. Okay, so that's the challenge around trade secrets. So if you are able to keep it secret, its term is indefinite. Okay, so now something, and this I'll just go in quickly because Karim is going to talk about that. IP and business, okay? It plays into business. So I will just to say that a patent, so it allows you, it protects your innovation, and it allows you to stop infringers from copying you. So when you have your patent in hand, you are able to stop someone who is copying you, okay? And one thing we hear about patent a lot is like people will say, oh yeah, so what's the point of having a patent if I don't have money to stop people who are copying me, okay? That's fair enough, that's legitimate, but the thing is, when you are really into research, like you are maybe starting a company, when you protect your intellectual property, it puts you really in good shape. Okay, it puts you in good shape for maybe having someone be interested in your, maybe being a business partner, maybe buying or your company or something like that. So it puts you in a position, a very, really attractive position for acquisition. Okay, and so when you have your innovation, you have a patent on it, you can commercialize it yourself, or you can just give licenses to people and just collect royalties. So a patent is really like an asset, okay? It's in the form of asset we call intangible asset, but it's really like a building, a machine, it's really an asset that you have and you can exploit it the way you want. There's so many, today there are so many creative ways of exploiting your intellectual property. And also sometimes some people would just want to have a patent on their innovation just for the prestige of saying I have a patent. Okay, so it's a legitimate reason as well. Okay, as I said, so we will, when Karim talks, we will see really it plays into business, how it can make you be successful in your business, patent on your innovation. Okay, so briefly also, this is an example. I'll just show you an example of how the technology can be protected, is protected by a combination of many forms of IP. So you exploit it and make your term, your protection last longer. Okay? So for example, this is your innovation is a composition of matter, a product that you have invented. Maybe it's to cure cancer, maybe it's for something else, we don't know. But you are selling it into this water. So your water is in this water and then you are selling. So this is what's on the market. So I will show you how the combination of IP will make the term last long. So for your composition of matter, the product that's in the water, you can have a patent on it. Okay? And its term, as we just saw, is just 20 years from the time you file the patent application. And also, when you look at it, another opportunity for a patent can be this mechanism here. Okay, so there's a special mechanism designed here to close the water. You can have a patent on it. So right now you have two patents. You have a patent on the product, you have a patent on the mechanism. And then for your product inside here, maybe you have a patent on it, but there are still some aspects that you haven't disclosed in the patent. It usually happens. So we call it sometimes know-how. So there's a special know-how around your product that's not disclosed in the patent, and you have decided to keep it a trade secret. So if, as we just saw, if you keep it a trade secret long enough, this protection is indefinite. See? And then maybe you have invented a word for your product, to sell your product that you wrote here. And that word, you can obtain a trademark registration on it. Okay. And also you see the bottle has a special shape. Okay. And you can obtain an industrial design protection on the shape of your bottle. And maybe you wrote down a text instructing people how to use your product. And that text can be protected by copyright. So right now you see, when the terms of the patents, the industrial design are done, 20 years, 15 years done, your trademark, you keep renewing it, indefinitely, the protection is still there, your copyright is still good, and so your product is on the market, maybe your patent is dead, the industrial design is dead, but you still have protection. Okay, you still have at least some protection. And by the time competition catch up, so maybe when the patent's there, the industrial design there, competition start to catch up. But your products have been on the market so long that competition will have a difficulty catching up. And you will still have, and your trademark will have established itself, and you see, so you will still have an edge on the competition. See, so that's just a way, showing us a way. And I took this example of a product curing cancer or another disease. It can be something else. It can be whatever your field of research is. You just to show that you are creative, you design a combination of form of IP around your product, and you can maximize the term of protection. Okay? So really, among the forms we have seen, and I know that you guys are mostly interested in patents, it is usually contrasted to trade secret, okay? Because the basic principle is that you have an innovation, you have two options. You can decide to file a patent for your innovation, or you can decide to keep it secret. Okay, so you file a patent, it's good, you have a patent, but the drawback is that the term is monopoly is limited, only 20 years. And you can decide to keep it a trade secret, and the thing is, the good thing is that its term can be indefinite, but the challenge is that keep it secret. The challenge to keep it secret. As you can all imagine, not all inventions can lend themselves to being kept secret. If your invention, for example, the bottle we just saw, the mechanism of to close the bottle, if that's your innovation, if you decide to keep it as a trade secret, I mean, just looking at it, give your invention away, so you really don't have a choice to go through a patent. So let's say from now that your innovation, you look at it and you said, okay, there's no way I can keep it secret. Okay, there's also the reverse engineering thing. So if you have a competition, if you give it to some chemist, he goes into a lab and then he can reverse engineer it, so there your invention is gone. So anyway, so let's say from now, you look at your innovation and you decided that there's no way I can keep it a trade secret. I will just file it back. So now what do we do? So from now on, we talk about patent. So, as we alluded to already, a patent is really basically an agreement.
Can we ask questions or wait until the end? I don't know what's there.
Oh, okay, go ahead.
Yeah, what are the decision factors for trade secret versus patenting?
Okay. So as
How do we
we,
decide which is best?
so the first thing is just looking at your innovation, giving away your innovation. Like we saw, so we said this thing can be protected by a patent. Okay, so let's say you have invented this mechanism to close that button, and then I think that you just look at it. If someone looks at it, there you go. That's your invention. In that case, the choice is easy. You need to find a patent, because if you decide to keep it a secret, it won't be a secret at all. Once it's on the market, anyone will see it and turn around and make it and sell it, and you won't be able to stop them because you don't have a patent. Okay, and maybe we also said that the product in here, that composition, if you decide to keep it a secret, the chemist buys the product, takes it in the lab, and then just reverse engineering. Just maybe a chromatography or something like that would just give away what is in that product. And so
In this specific case, everything should be patented, nothing.
exactly,
Secret.
exactly. Yes.
So I've worked a bit in with batteries and battery materials,
Yes.
and I found that in that particular case, even if I were to reproduce what's in the patent, we would not end up with the same values, connectivities, energy density, etc. So the materials are so complex, there are so many entrants that they give away patents, but they're not giving away their trade secrets. They still have both some way.
Exactly, what we call a know-how. Sometimes we will have, in Europe, we will have a patent, but there's sometimes always a know-how that people won't have in the patent. Okay. So Does that answer your question? Okay. So we said, you were just saying that the patent, just basically defining it's a monopoly that the government gives you, a limited monopoly for 20 years. And that gives you the right to stop people who are copying you. And so in exchange for that monopoly, the thing is that you need to describe your invention in detail into that document, such that at the end of your monopoly, anyone can just take the document, read it, and reproduce your innovation. Okay, so I know that goes a little bit. What you just said challenges it a little bit but theoretically, normally, okay, so that's the aim of the patent. The patent, you describe your invention in detail, such that anyone can just take the document, read it, and reproduce it.
Anyone qualified?
Anyone qualified, yeah. In the jargon, we call it a person skilled in the art.
Yes.
So someone skilled in the art can just take it, read it, go and reproduce it. So that's the exchange. So the quid pro quo, as we call it. You have a patent, you can stop people who copies you for 20 years. In exchange of that, you disclose your invention in detail. And then at the end of your monopoly, anyone can just reproduce it and also sell it, benefit from it commercially. So that's the thing for patent. Okay. So we will talk about the subject matter, what can be granted the patent, the prior art search, the patentability opinion, the patentability criteria, filing strategies, examination process, best practice for strong patent. Okay, so I would say, by the way, that we don't have like the entire hour, but I have put on the slides more than this. So even if we are going too fast on the point, that's fine. You can maybe read the slides and we'll be able to. And we are always available. You can reach out if you really need to know more. We are always happy to help. Okay, so this is the definition of invention. The word invention that we find in the Patent Act in Canada. Okay, so an invention is a new. So I've underlined terms that we will talk about more, but these are the important terms of the definition. A useful art, process, machine, manufacture, composition of matter, or any new and useful improvement of all this. Okay. From this definition, it stems that these 4 points stems out. So patentable subject matter. Not everything is patentable. Not everything can be granted on. But I'm sure in your field of research, okay, in the batteries, we don't have that type of programs. Okay, usually what you guys are working on fall within the category of a patentable subject matter. Usually we are able to draft like relatively straightforward claims, and they will fall into categories of patentable subject matter. We don't have that problem in your field. So in this field, in people who work in the pharmaceutical, sometimes in Canada, when they want to patent like method of medical, how to treat something, so the patent office will say, no, it's not a patentable subject matter. Okay? And so also some computer-related invention, okay, so they should work really with the patent agent to see how to draft the claims in that field. But as I said, in your field, I think you guys don't have that problem. Okay, so from the definition of invention, again, as we just saw, these are the criteria for an invention to be patentable. So it has to be new, it has to be non-obvious, it has to be useful. Okay, so novelty. Okay, the test for novelty, just quickly, is that yes, you are saying that this is your innovation, but we found this document that discloses your innovation. And the test here, really, the important point is that it should be one document. So if the patent office is saying to you that your invention is not novel, it has to find one document that when you read that document, your invention is there. So when one single document is disclosing your invention, they would say your invention lacks novelty.
All of them or partially? It has to be all.
All, for novelty, for this point, for this criteria, novelty, all your invention
Is contained.
into one single document. And again, as I say, when I say all your invention, I mean the invention as described in the claims. Okay.
From the novelty perspective.
Yes, from the novelty perspective. Even even for the all 3 criteria, what I'm referring to here is the invention as defined in the claims. Okay, I'm switching to claims now, but this is a part of a pattern. I think Simon's going to show you a pattern, and as you see, probably, I'm pretty sure, who hasn't seen a pattern here?
Has not?
Has not seen a pattern. I think all of you have seen a pattern, okay? You haven't seen a pattern? Okay, Simon's going to show you a pattern. But the claims, just to say, it's a part of a pattern. It's a very important part. Let's say a pattern looks a little bit as a scientific article, but there's this part called claims. That's not in any scientific publication, but that's very important for patents. So yeah, your invention as described in the claim has to be novel. So if the patent office is saying otherwise, they need to show you one document that discloses exactly the invention as described in the claim. Okay, now the second criteria, obviousness. This is the place where the patent office will tell you that, okay, we haven't found any document that discloses your innovation. Okay. We haven't found any single document that discloses innovation. But we found this document, A and document B, let's say, that when you combine them, there, that's your innovation. Okay, or we found this document, and based on what the person skilled in the art, in that field knows, if they combine that document and that knowledge, they arrive at your innovation. To just in brief, for obviousness, okay, there needs to be at least two sources of prior art that are being cited against your claims for it to be declared non-obvious. Okay. And then for okay, just maybe to say here, obviousness, okay, this is an objection that we get a lot from the patent office. I mean, more than, I would say, I don't have the exact, don't quote me on that, I don't have to say exact number, but I would say more than 80% of patent applications that we file, the examiner will come back and say, oh, no, it's obvious. You know, after the fact, everything is obvious. Anyway, so we deal with that a lot. And we have developed arguments, way to counter, to really deal with that. And I just put a few here, okay? So for example, the examiner say, okay, yes, please, we will try and see, and we work with you, the researchers, we'll try and see what are the unexpected results. Yes, this is one that's usually small. So maybe your invention, maybe there's something similar a little bit in the prior art, but when you are doing it, you are obtaining some unexpected result that was not found in art. So we will bring that to the attention of the examiner and then try. So there are many ways of arguing against obviousness. I've put many of them. I won't go into. We would stay here till the evening. So, and then now the third criteria was utility. Okay, so this is where really we want to see, does the invention works as promised? Okay, is the disclosure sufficient? Do the claims claim more than what was invented? Okay, so basically, this is a criteria where the patent office, the patent system, we don't want to be giving you a patent on something that you have not invented. We really want to give you a patent commensurate to the scope of what you have invented. And also, this is where really we want to see, have you really described your invention in detail? Okay, so we really do. So this is this is the criteria that examines that. Yes.
This doesn't say whether you have implemented the actual patent invention or not.
No,
You don't have to have kind of made it.
Yes.
You could patent something that you plan to do in, let's say, 5 years.
Okay. Yeah, I would say yeah, but with an asterisk here. Okay. So it's always good. You cannot just patent an idea. You cannot have a patent on an idea. So even if you haven't really completely built what you think what your innovation is, you need to be close. It will be helpful. Because there's also this part in the patent, the examples, okay, experimental section, where you need to prove that you have conducted some experiment around your innovation and you have brought it to almost completion. See? So if you are it's just idea. Do I explain it to you? You don't seem convinced?
Yeah, because I have seen patents that have not been implemented at all.
At all.
At all. It's the
Okay,
idea.
one thing I can tell you right now is that the patent, so it is when it's issued. So when you file an application, it's examined and then it's issued. it is presumed valid, but it can be challenged. Okay?
After the fact, though.
Yes, after, when you already have a patent, it can be challenged. So, and this is something that's done a lot. Maybe a competitor, they want to launch a product, and then they find out that this patent kind of, maybe if they launch their product, they can get sued because of that patent. They will try and see a way how to.
Challenge yours, okay.
Exactly, but if there's, there are many patents, so just to say that there are many patents out there that, okay, they issue their patents, but if someone wants to challenge that, they can. Okay? Now, one thing very important when you think about an innovation, one thing very important to do is really, before you launch into drafting a patent application, is to do a search. So we just saw there are really two strong criteria in the definition of invention, novelty and obviousness, that rely on what's already disclosed out there. So it's good for you to really take the time to do a very good search to see whether your innovation can be to see, let's say, the probability of you getting the chances of having a patent. It's good to have a search, because the thing is that when we file a patent application, the first thing the patent examiner does is to do a search as well. Okay, and then so you don't want to spend all the money of drafting, filing, and then you file, and then the examiner, then that document, that exposure, that kills your innovation. And the search for patentability, you can do it yourself, okay? And then there are also out there, there are professional searchers that do that. Okay, and very important for patentability search here, you consider, I would say, everything that is disclosed is considered. And I contrast this to, you remember we said that, so when you want to launch a product, okay, on the market, the first thing you want to do is to make sure that you will not be infringing someone else's patent, right? So there's this search that got freedom to operate search. So you do a search to make sure that you will not be infringing other people. And the databases that you will consider are just patent databases. Okay. And so, and in the jurisdiction where you want to launch your product. Also, you should also consider the database of the international applications, because you don't know what they're going to do next. Okay, so I contrast this to the patentability search, where you really need to consider everything in all language worldwide. And this is something that we see some inventors, they said they have done the search, and what they have done only is just maybe look at patent databases, or maybe just the scientific literature. Actually, you should look at everything in all the languages worldwide. Okay. And then, so maybe this is like even a step a little bit backwards. That we're taking a step back a little bit, just to say, to state this very important point when you are working in research and you want to patent, and you think you may patent your innovation. The thing key is the confidentiality. You should really keep your innovation confidential. Okay, you shouldn't go out publishing it. Okay, because we would say that there are some jurisdictions where once you have published, once you have disclosed your innovation, can be barred from obtaining the patent. And particularly this is Europe. Okay, if you disclose your innovation not under a confidential agreement, you really are barred of having a patent in that jurisdiction. So there are other jurisdictions where that give a grace period. So if you disclose, you still have like the year. So to file a patent application and obtain the patent on it. Okay, so those are countries like Canada, US, Australia, Japan. When you disclose, no panic. If you file your application within the year of that disclosure, you will be fine. But Europe, it won't be. So basically, the thing to know here is just keep it secret. And the advice is to file first, then disclose. And there are ways of helping you, ways of helping you file quickly if you think you need to disclose very soon. Yes.
Is there any way of doing like limited disclosure, which it's understood that that wouldn't violate a future, invalidate a future patent? Say you were you were socializing your idea with potential collaborators or stakeholders, users, kind of thing that we're doing. In all of those instances, we lose our chance of a patent full stop, do we? Or is there ways around it with some kind of other agreement?
Okay, yeah. You see, if you discuss on the confidential agreement, that's fine, you can be fine in your. But the thing is, do you really trust these people?
Oh, sure.
Whom you are discussing? And the other aspect of this is that the word is first to file now, okay? The first person getting the innovation at the patent office is the person that will have a patent. So what if you disclose that that person runs in the patent office and file a patent application before you?
Okay, so you create risk,
Yes,
but with the confidentiality agreement, you create risk, but you have still left the door open to the patent still being.
yeah, you can have, yeah.
Okay.
In case of a lawsuit later on down the road, okay, that a confidential agreement can help you in any way. But as I said, so there are really good ways, very we see soon, very to apply this, it's really easy these days. The system, the patenting system has made things easier for inventors to be able to file first, file quickly, okay, and then after that, make your disclosure. Okay, and you can jump onto that right now. So when you are filing your patent, you are thinking of patenting your innovation. So the first thing, as we said, is really to align your business strategy with your patenting strategy. Okay? Because I don't know, maybe we didn't say it, but the patent protects you in the jurisdiction where you have a patent. Okay? Canadian patent protects you in Canada, not in the US. The US patent protects you in the US, not in Canada. Okay, so you need to really design. So where am I going to be conducting my business activities? And where are my competitors maybe? Where are all the manufacturing processes are going to be taking place? So we really need to think all this carefully before when you are selecting your patenting strategy, where you are going to file for patent application. Okay. And then so there are international trading that makes things really easy, like facilitate things for innovators. So there's this one, the Paris Convention for the Protection of Industrial Design, industrial design property. So this is under this treaty. So you file a patent application in the country, and then the effect of this that date. So when you do the first filing, you have a priority date, and that priority date will go in all the members countries of that treaty. And today there are 180 member countries, so almost basically all industrial countries in the world.
China is there, China?
Yes, China is there. So this is because of this though, probably many of you have heard of the US provisional patent application. Okay, so this is really something though. So for us here in Canada, it's easy. When someone wants to say the same, come to us and say, okay, I have this, and I will be speaking to a potential investor next week or maybe even tomorrow. What can I do? We need to file something quickly. So we will advise them to file a US provisional patent application. This is a patent application that you file. So you have that priority date that's going to go in all these countries. Okay, and then you have 1 year to file the real thing, the formal patent application. Okay, so, and the beauty with the US provisional patent application is that if within that year, okay, things turn out that, okay, maybe you won't continue with that patent application. Okay, you will just leave it die, and it will never be published. You just leave it. So you just leave at the end of the 12 months, you do nothing, and then it will just die and it will never get published. Okay, so this is a mechanism that really allows you to, when you feel you are in a hurry, you file that, and then you publish, you speak to people. When you start speaking to people, you can just even tell them right away, there's this term, I am patent pending. And you can give them the number, the application, and then that makes you really, and people understand, so they cannot steal your impression, because you are already the first at the patent office, you already filed it. Okay, so for me, it's stronger than a confidential. And it's cheaper to file, and as I said, it will never get published if you don't do anything at the 12-month period. Yes.
So the novelty part says that if there's any mention of invention on the internet, for example, you cannot file a patent with these claims. Right?
Okay.
But then you have to patent in every country that you want to exploit the patent in. Why can't I just patent in one country, and in that way I'm sure that no one else will be able to patent or use that patent in another country because there's already that novelty part.
There are many points to, many aspects to your, so this is, you are mentioning, your comments, there are some defensive things also, okay? I can even tell, so some people, they have an innovation, maybe they don't feel like having a patent on it, what they do, they publish it. Okay, because in that way, that makes that nobody will be able to have a patent on that innovation anymore. They don't even need to, they can find a patent application, as you said, yeah, or maybe they just publish it online or something. Okay, so yeah. And maybe I lost other aspects of your question.
So I think it's for exploitation. If someone else exploits my license in another country, although I didn't.
Neither. Okay, yeah, maybe something I should say again on your comments is that we saw that a patent protects you in the country. So if you have a Canadian, let's say in your what you just described, you have a patent in Canada.
Yes.
You can just act in Canada for that. So if someone is copying you in the US, there's nothing you can do. There's nothing. Okay, they can just, maybe they will be happy just copying you there without having a patent.
And they don't have to pay me.
They don't have to pay you.
Because
Only in Canada, they would have to pay you.
This convention doesn't help. This convention here.
Or if you didn't act on it, it doesn't help you. So you find it, and then finally you have a patent only in Canada. That's it. Your protection is Canada. That's it.
They can't patent it, they go back.
Maybe I can give you an example, okay? For example, you have Brazilian countries, people they never do any, usually they patent in Canada, USA, UK, Europe, India, China, Korea, Japan, okay? And there are other countries, when they sue the patent, and these guys, my experience, over 90% are honest. They write to you, you have no patent there. For example, I have experience with Brazilian companies, and they said, okay, I am interested in your technology, but you have no patent. I don't like to infringe you, I don't like to. And then what you do, you make with the lawyers and IP lawyers, you make like special agreement, you call it transfer know-how and everything, technologies, and then they pay the front payment and they pay the okay.
That's good. So that this is where the know-how would becomes really important. You don't have a patent in Brazil, but if you try to copy your invention, you want to.
They read your patent, they cannot produce it because inside the patent, if you are naive, you write everything, so please forget about that. So you keep trade secret and you keep some know. And then you package as what you call it portfolio of the patent, know-how, and trade secret together.
Perfect. So yeah, these are the way the licensing agreement would work. So there will be clauses to use the patents, and then also clauses to transfer some know-how that goes with the in that technology. Does that answer your question? So yeah, we were the filing strategy aligned with the business strategy, and then these treaties, international treaties that help facilitate. So I talked about this one that gives you the priority date. This one is very important also, the patent cooperation treaty. So this is the treaty where, so the scheme has been designed that where you file one patent application, okay, and the effect of that one filing, international patent application, we call it PCT application, is as if you had filed in all the members countries. Today they are 158. But I just said the effect, okay, because you actually at one point need to what we call enter national phase in this jurisdiction in order to get to start the prosecution and then you ultimately have a patent. Now you are protected. But at least, okay, because the patent protects you, we know it protects you in one country. So that would have, without that, the thing would have gone this way. So I have an innovation. So I want to file in Canada, US, Europe, Japan, China, India. So you need to file right away in all these countries. And that would be very expensive upfront for inventor. Okay? So now with this process going through the international patent application, you file just one international patent application and you have many, many months. So delay the cost gets delayed, and then you decide ultimately what countries you want to select to really go national phase into and then have a patent. So these are processes that have been made to kind of facilitate the patent process. How are we doing on time, Karim?
Yeah, I think we can take some questions, or if there are no questions, we can continue for another 10 minutes.
Okay, that's fine. Now, so I think but it would go faster now because we already touched about on all these. So the finance strategy, so usually this is the way it goes. Typically, it can vary, but typically this is the way it goes. So you have an innovation, you quickly file the US provisional application because usually when you are feeling that I'm into something good, maybe you haven't completed really the experiments yet because those experiments are important. Okay, later on they are important for the established utility. Okay, so we file the provisional application, and then that gives you 12 months to really complete your innovation, to really perform all the tests, the experimental data, obtain experimental data, and then at the end of the 12-month period, we file the regular application, which is usually in the form of an international PCT application that you just mentioned, based on that treaty. So we file that, and then after a few months again, now we need to select your countries of interest, your jurisdiction of interest. Because I said jurisdiction because we talk about country, but for Europe, you can proceed by selecting Europe as a word, and then the division will come later. So this is the classical way. Yeah, and so this slide really just to say that when we are drafting the patent application, it's a collaborative work with you guys. You are the experts, so we work together to draft the patent application. We file it, okay, and so we file it at the patent office. We already said the examiner takes up the case, and then the first thing he does a search, and then so this is when the examiner starts. This is where the prosecution of the patent application starts, okay. And then the examiner does the search and then issue what we call an office action. I'm sure people who are maybe inventor on the patent application, patent, know this term, are familiar with this term, office action. So this is what the examiner, they do their search, they examine the application, and then they issue an office action. This is where they say, okay, your invention is not novel because of this document. It's obvious because of this document. And then all sorts of objections they can raise. And then we take it and we work with you to respond to the office action. We file a response, and then it can go back and forth maybe 2, 3 times, maybe 4 times, depends. And then when the examiner is satisfied, and they say, okay, yes, now you have a patent, they issue a notice of allowance, and then the patent is issued. And while prosecution is going on, okay, this is also something important, the third-party intervention. Okay, maybe just on one point to say that the patent application, 18 months from the priority, it is published. Okay, so it becomes a public document. And this is where competitors monitor their competition. Okay? And when they see a patent application that they may disturb their business, okay? They can start doing their own prior art search, they found document, and they can write to the patent office under this, and then say to the examiner, yeah, we hope you are aware of these documents. They are relevant to the invention. The invention should not get a patent because of these documents. Anyway, they can intervene that way. But the examiner does not need to respond to them. The examiner just takes it and then assess on their own and see whether they are right or not. Okay? So this is how it works.
What is the cycle in terms of time average? I know it's probably different from one industry to another. Or from
From one country to
when we
another.
start with the idea until we get the application, not the patent itself.
Yeah, as you said, it varies a lot. And also, there are processes to accelerate it. Okay, so it varies depending on technology a lot. Okay, let's say maybe in this particular technology, it takes 3 years for the prosecution to have a patent. You can file what we call a special order or request for acceleration. Yeah, good one. And it can cut the time by maybe half or even third. But it varies depending really on the technology. And then the patent issues. So there are things that can still be done. it can be re-examined, maybe it's issued, and then some other documents came to light that the examiner didn't consider, maybe by you, or maybe by someone else, by a third party, they can ask the examiner to re-examine the application, okay? And then the reissue, maybe it's issued, the patent issued, and you saw some error that you want corrected. You can ask that. And then the last thing is that we said it can issue, but it's challengeable. So anyone can, but now it won't be at the patent office, it will be at the federal. So you can launch a validity attack on the patent and get challenged. Okay. So these best practices, really, I won't say much. Okay, I won't say much on it. And really, we are, as I said, we are there. We are really always available to help. If you will have the slides, and any of this is of interest to you, feel free to reach out. So the invention disclosure is really like when you are in a group, research group, you are working with an organization, there should be at least some form of arrangement to make sure that things are not disclosed are not disclosed, or people, let's say people are going to conferences, so there should be a streamlined process to really make sure that at the intern there's a form of having an invention disclosure. And so we've touched on all these points after the innovative grace period. So yeah, we are still stressing on invention disclosure here. And yeah. One point very important also is the inventorship. So who is really an inventor on a patent, on an innovation or patent application? It's different for from authorship. That's a very important one. It can be the same thing, the same idea, okay? When you file a scientific publication, then maybe usually, I remember from my time in research, we can name almost anyone who has worked on that project, okay? But for inventorship, it's different. Inventorship, there's really need to be a way, and it's important in the field of patent because the inventors are the first owner of the patent. Patent belongs, normally that innovation belongs to the innovators, and then maybe there are some, they need to assign their rights because of maybe employment agreement, financial consideration, compensation, they assign their right to an institution, and the institution becomes the owner of the patent. But the first people are owner of the inventors, okay? And just briefly to determine, so inventorship, okay, is determined like a two-step. The US established it very well. The first step is conception, and the second step is the reduction to practice. Okay? Someone is an inventor if they have contributed to the first step, the conception. If someone has just worked in the lab for the reduction to practice, I mean, just carrying experiments, like they told him, the person who conceived told him, do this, and normally they are not inventors. Okay? Those people may become inventors if, in the process of carrying all these experiments, they have come up with some other idea to improve innovation, and now they step into the first step of conception, and they become inventors. Okay? So that's the idea. There are many, you will read into that, and then there are many points, specific points that you are mentioning. And also, I just thought I would just finish with this. The collaborative research. Today, as you know, probably the research is not conducted just within your group. Sometimes you need to collaborate with external group in another institution. Okay, so they need to be really paperwork well written and the agreement with all the important clauses to make sure that things go smoothly. Okay, that's it. So yeah, still some point on collaborative research. And then I left some resources here. There are many resources, even on the Canadian website, Canadian Intellectual Property website, there are many resources there if you want to know about that. And then, yeah.
Any final questions, or should we have another one?
Is there any question on the chat also?
No.
I was just going to say, one of my big areas is, our project areas, I should say, is copyright, which you just at the beginning.
Yes.
So we probably have some cause to have to write patent as well. for inventions, but there's copyright issue. Is that something that Lavery would also?
Oh, yeah, of course.
Okay, great.
So we have a group of intellectual property. There are people, as you can imagine, I work in the patent field. There are many of my colleagues who are trademark specialists, copyright specialists. Yeah, we can help with that.
Great, thank you.
Yes.
You explained well the process. I went through this process even before. But I think it's complex and it requires like professional help, because one of the requirements or thing you said, you have to search everywhere, any language, and I don't think like a researcher will be tempted to do that work himself or herself. So maybe the help of like partners or professionals in the field, and also tools. So I've seen tools in the past where when you create the patent itself or you start the process, it's not just like a corridor conversation. You have to go through like let's say a portal where you start entering your idea, answering questions, and then that will start like
Yeah.
let's say in French, the minute.
Yeah, searching is very important. Even I don't do searching myself. We work with external searchers, professional searchers, specialized in that. And really, ultimately, no search is perfect. Okay, no search. That's why there's a re-examination program, there's the challenge validity, because people would, even afterward, make their own search and they can still find document that we didn't find. No search is perfect, but it's important to at least do something. Yeah. Thank you.
So Simon,
I work with Karim Zaghib for IT specialist, and I'm a electrical. I have a background in electrical engineering. So and 25 years in the patent management. So I see everything possible in patent. A disclosure before the patent filed, everything. The inventorship not very well. So for this presentation, I will explain you different part of patents, especially for PCT publication and for the US application with information disclosure statement. So it's the same part like international research report, then information disclosure statement. It's a little bit the same. So this is a PCT, or you see that if you see a document PCT, you have this front page. It's the one page, and I mentioned the information, the main information that it's important for you research. Okay, you have a priority document, the filing date, filing number, and international patent classification. So you can find other patent in your field with the classification, publication date, publication number, filing language, and publication language, assignee, and inventorship. Of course, title and abstract. So in the PCT publication, you have the background of what was the problem of the technology. The background is that. After, you have the disclosure of the invention, what you do, what the new idea, what the solution of the problem. And particularly, you must find an example of your invention. So it's very important to make many examples to explain very well to the examiner the new invention. And you have the figure here, and like you see, it's just a number. Okay, that's format. It's very useful for the translation of the patent when you file in China or in other country. So if you make your figure, it's useful. Sometimes you don't have, but now you have to. I like this format of because you have no translation on because in your in the example you explain each part of the figure. So it's very easy to translate in other language. Okay, and that's
What is the difference between the numbers that are underlined versus the ones that are not? In the previous, or is just like the design that has like 160, 150, those are underlined.
that will be explained in the figure detail. So you have in some of involvement electrochemical cell 110. You have 110, you have 110 here, you have chemical cell. So you explain in the document what is your figure, not the figure explained in your, not the figure explained. Okay. So you have a part of your patent that explain your figure. Okay. Now you have the International Research Report. This document is normally, but not always, but mainly, it's with the publication at 18 months after the priority document in BC. Sometimes it's more time because it's a big patent, then the PCT will publish after the international report. So for this part, very important to see if you have X or A, because that's, you have some category of documents cited. So it's very important to see if it's just prior art or very if it's your document, it's the same as yours. So at the end of the document, everything, every category is very well explained. So every PCT have this format. Okay, for US, it's a little bit different. The format is different. Yeah, like you see that you have international classification. Also, the title is on front. Assignee, inventorship, filing number, filing date, priority document, publication number, publication date. That's US. Now you have a US patent classification. That you don't have it on BC. And the abstract. And now you have the figure. Okay. You have also the background art. So what is the problem of the present technology? And after, you have the summary of your and detailed description of your solution. Also, you must have example. And at the end, you have claim. And also figure detail. So mainly, it's just the format that the same information is, you have the same information to work with the patent agent, but the format is different. So in US, you have another document that you will see. It's an information disclosure statement by applicant. So it's the same, you should file the document that your background, you think it's near your invention, but not your invention. You have to sit in the USPTO, US Patent and Trademark Office. So you have to list US patents. It's a format. You have to sit US patent application publication, and have foreign patent document, and you have publication, non-patent literature documents. So it's just the same document, but it's in another format. And when the patent is issued by the USPTO in the procedure, when you answer all of the office action, when everything is good for you, you have a patent with a date of patent, not a publication, but now you have a patent. And you have a new number. And it's the same as a patent publication, but you have a new number in US. So now we will talk about the patent, the IP protection strategy. So you have two ways to file to extend the protection of a patent. You have to file a PCT or national strategy. And I will explain you how to each step for granting a patent in different countries. So as you see, you have the first document is a priority filing for us is in Canada because we are Canadian. It's easier. And after we have less than 12 months to file PCT in Canada, but by PCT. And at 18 months, you will find PCT publication with international people. Sometimes we file the US at the same time as the PCT because we want US as soon as possible. So you will receive also a US search report. This is very interesting because you don't have to translate the application, all of the application, and it's very difficult to. You have a lot of work to do that the same way. So I prefer this because this, when you use the national strategy, you file a priority filing, the first document priority, and after the national phase, or for each country you want. So you have to translate each document at the language of the country, like Chinese, Japan, everybody. But with the PCT, you have an option to file the national phase at 30. Wow. So work very well at this moment for filing a good patent. And after you have to work to translate it if you are also interested to protect the inventions at this time. Now I would just want to explain you each step for granting a patent in a country. Like in Canada, you have to file at the first time application after normally 18 months, you have a publication, and you can file an examination procedure in Canada, and after normally 3 years, you have a patent, and you have to pay also annuities for each year, like your house. Each year you have to, and the price level short anytime. You have also in China the filing publication, and you have to file an examination very soon after the filing. And after you have the patent, and the annuity begin with the filing of the granted patent. For the European application, you have to file the exam with the application. The application will be published, you grant a patent, and after you have to file regional phases for each country you want a protection. So you have also many translation. Sometime after 9 months, you could have a position for others. And you have also annuity for 20 years. In India, it's like the same that in China. So the time it's different, but the same. In Japan, it's like India, Korean also, but US it's different. The US is like European, but the annuity is after the US issue. So the first, you have the 3 annuities to pay each 4 years. If you have any question.
The annuities, they don't seem to be like all aligned. Some or majority, they start when the patent is granted, and the others,
Yeah,
you even start paying before your patent. So if you don't patent at the end, you just pay like for Canada, for example, you start at year 2, but the patent could be, let's say, objected and then. not
yeah, maybe
granted.
you could have a patent at this moment, so you have to pay if you want to keep your rights, you have to pay the annuities. If you don't pay, the case is closed.
Okay, so it's a protection while you're patenting to pay those.
But what if you start paying and then you don't get the patent? Do you still keep paying?
Yeah, each year you have to pay an annuities in Canada. So like you see, it's different depending of the country. So in the management, we have to, and we have a company, international company that they pay all of these annuities for every patent in Canada currency. So it's easier for us to do that.
What's after 20 years? Because I heard earlier that after 20 years, there's something, from this process perspective, is there, for example, the annuities stop?
Yeah. Of course.
And
You lost your rights, so you lost pay.
You can't extend. I
No,
heard like
never.
extension
No, never. You can extend if you have a new ID
tied to the same or something completely new.
that protect your business.
You can extend if you have like lawsuit infringement. And then you was in the law for like 10 years, so. Depend of the bureau, like in China, others, you can have some extension, but not huge. This is some exceptions.
Yeah,
Maybe
maybe
exception.
sometimes we have exception in US, they extend the term of
Yes.
the protection, but mainly it's 20 years.
20 years become public company, any person has the freedom to use.
Yeah, that's the quid pro quo. And maybe Catherine, you said, so if during prosecution, so Canada, it starts 2 years, 2.5 years after. If during prosecution, maybe you are in a dead end and you just say, the examiner is saying, oh, it's not new, it's not novel. And then you decide that, no, that's it. I mean, but I'm leaving it. I don't want the patent anymore. So you stop paying as well.
Yeah. Stop.
Okay, but it's not.
Last session, Jack. Okay. Who's your time? Yes.
Camera is here, okay. Sorry, I'm old style guy, so I have no slides, I will just use paperwork like that, this is what I learned. Because when I know it was not Mac, was not PC, so I was just using the word, okay? So, Beatrice, thank you so much, so I have experience to work with Beatrice and Simon, this is what we are here to help. One thing what I saw, what I learned, especially in academia, many of the professors, sometimes I feel sorry because they publish great work, but they must be patented. And they bring millions and creation of jobs. And then other they saw it and then they take it and so on. So IP patent versus publication, I think Beatrice and Simon explained. Myself, I am author of 1,080 patents and they publish 450 publications. Because they were thinking that the professor, when they do patent, he cannot publish. No, you can publish first, but we must avoid the mistakes. I will explain the mistakes. As Simon explained in detail, you can file the patent, you have your patent, and then after the review, of course, the student, they need master, they need PhD and so on, but just patient about 1 year, 1.5 years, and then you can publish any journals, okay? Of course, they explain publication, how you draft the publication is different to the patent. But when you draft publication, is easy for you to draft the patent, it's not big. So what I suggest always is try to make the first draft by yourself and always work with Beatrice on collaboration with Simon. Is in mechanical, electrical, chemistry, and then you can have a great patent and so on. I think, of course, when I saw these guys, I know people want to have these high impact journals on science and nature and so on, but the patent, sometimes we do something useful for our society. So we can take both of them, but just think about patent, especially in my conclusion, I'm going to speak about there are some, I think you asked a great question about reproducibility. There are some patents, there are no any examples. You can patent ID without no examples. But in some countries, if you go to China or Japan, they will ask you to. By the past, as I said, when life can put more the detail. Infringement and lawsuit, I have been to many lawsuits, is very, very expensive. So you need to divide your ID on the patent, trade secret, and know-how. I can give you one example of trade secret that you cannot patent it, okay? So you have like two interfaces, you have like two materials. and then just using toluene. And then put toluene in that, and then all these two surface bleed. If you patent toluene like that, you never collect any money. You cannot collect, you cannot patent it. It becomes like trade secret. And then when you license, I'm going to explain the license. So you package this one as portfolio, okay? So we example and no examples, but especially if you have like basic patent, great patent, you need to put great team to make examples is very important because the claims and so on. And then try always to make it broad, like taking all the periodic table, and then you can see how to make. And after that also, you can making like fruit. Your patent become like bag of fruit, banana, strawberry, and so on, because this is very important to have this kind of portfolio patent around your patent. In order that you want to develop another technology, try to focus on this one because it's basic patent. Okay, so this is the IP, basic patent, portfolio, and publication versus the patent. So we can do both of them. And please, especially if you are working voltage, think first about IP and the patent because we are looking to do some success story together. We are looking also to make some big impact here in Canada and Quebec. This money is coming from income taxes, government. So really we like to be sure that we can do something useful for our society, okay? So same thing here. When I write great patent, I know what it is. As he said, reproducibility is very important. When I license, the license is very important, okay? I have been 30 years of my life because I am authors, but you said it's conflict of interest. It's not conflict of interest because me, any patented when I was working with the company, I give all the patent in $1. And then I saw that the guys who patent their IDs, they are the good to sell the license. So we put small team, and you can see, I will give you the numbers, how much we license on the team, and how much we bring the money. So, of course, you must know the reproducibility. If you like to make the pilot, small pilot, this can help. And then putting all the package together, okay? So it's very, very important. Other thing, if you like to put your mind, research and development usually, and then we go to innovation, we go to IP, commercialization, and industrialization. I summarize this one in one triangle: basic research, applied research, and modeling. This is for engineering people. So when you do this kind of the stuff, you make around this one, so really you can come back with something very important that you can bring the money for university and so on. So this is another way to think about making this kind of the basic patent, and then you play on this triangle. What I can do here and here and here, okay? And then industrialization is very, very important, okay? To speak about IP and business, I never go to business school by myself. Okay? I have no business. I just learned business for the street and my experience, but I was ahead on all the business of the IP. The business of the IP, when you have something useful, great. I never use any marketing. You just make the great team and great technology and collaboration, open innovation. You cannot work by yourself. This is a big mistake. It's better you can collaborate. By myself, I was collaborating with some professor. His name is John Godinov, Michel Armand, other student, of course, early career person. This is you should be nice team. If you want to be in the lab on your name and then close by the door by yourself and check, you cannot success. You success with open innovation, with collaboration. And you can share because this is big money and so on. IP business commercializations. So the focus is number one. When you focus on some technology, you put the team and so on. And after that, patent has 20 years. I can teach you. The first thing that you learn, you make mistakes, I make a lot of mistakes, and then I learn, is the front payment. When you have great technology, we ask the trade bond. So I can tell you some technology that we develop. I ask that the company pay 10 million US front payment. because the time is running, and then you cannot collect a lot of royalties, and then you need audit, and then also you need good IP lawyers and IP business, both of them. Without these lawyers, you cannot succeed. It's teamwork. By the past, we sell 63 licenses, all the technologies. You can see what we sold. Any iPad, iPhone, EV, many materials all are coming from us. And we receive a couple of millions of dollars. And many of these millions of dollars was invested in education and also on health, because we are not receiving any money. We like just to do something useful and creation of job. Other thing also, for example, if you like to collect license here, we like also first to create jobs in Quebec and Canada. And then with business, you said, I want to put close Canada, Quebec. So the first gigafactory, the first factory must be here. And after that, you can do it anywhere. If you like to go to Mars, you can make factory in Mars. But let's start here. This is close Canada, Quebec are very important. Okay? I don't like to speak a lot. I need to finalize, to finish. So thank you so much. I believe you see 3 parts of the business here, 3 parts of the IP, really definition of IP with IP lawyers. One person has spent 25 years on his life to explain the IP, myself on commercialization and so on. So as I said, Voltage, we are looking for success, how to measure also, the impact are very important. And they believe IP, patent and licensing and creation of a startup with senior professor, with early careers, with students, and this is what we are looking. And they can tell you the IP patent, know-how, trade secret is the key, is the convertible. So we finish here. If you have any question, let me know.
With our paying partners in some of our voltage projects, I'm thinking particularly about the impact projects, which will be larger. We expect partners to stakeholders to contribute a fair amount.
Yes.
I anticipate conversations where they might want the benefit of some IP ownership of IP, transfer of title. Does Voltage have any sort of strict rules on that? Like that's just not possible, or only under some circumstances, or is it all to be negotiated?
We was working very hard with our chairman of advisory board, Norman, and we are working, of course, Voltage is under Concordia. So we need to work on the IP policy of Concordia. We are working with them. We presented our policy to the advisory board. My experience, the 1,080 patent and authors, 90%, it's almost 50-50. So we must, it's a win-win. If you are not making any win-win business, you cannot success. For example, if you are company A, you work with me. The IPs belong 50 to you, 50 to me. We win 100 millions, you will receive 50 millions, you will receive 50 million. So this is the policy that we can have. We're going to share the IP. It's a win-win relationship. You never succeed by yourself, and because some universities they want to keep this one is big mistake, or and this they want to keep is not good. Why you get 100 millions and they get 0? And the idea is coming from us. So this is what really I was doing for the last 30 years, so let's put the 2 eggs together and let's share the omelette together.
That's good.
To be fair, yes. Actually, I'm coming from the industry, I'm coming from Schneider, and one of the questions is, does this kind of policy or approach need to be clearly stated in the NDAs, or is, because I know we do have like NDAs with Concordia, so.
Yeah,
Covered
okay.
there already.
Yeah, listen to me how it works, okay? I spent 28 years in Hydro-Québec, okay, myself, okay? And before I was working in Japan, working with Sony, Panasonic, with these guys. When you spoke with Sony, it's license in, license on, NDA, and so on, okay? So I hate the bureaucracy, I hate it. And the time is issue for us, okay? Usually, let's see, your company work, let's give a concrete example, come with professor like that, okay? So usually what we can do, which is more easy, this is of course the office, and people with Voltage work with. It can go to the NDA, and then we can move, if we are not having any project before working for it, let's have, I like binding MOU, not MOU. I like binding MOU, because if you are making binding MOU with us, so means you are serious. And then you make this kind of the contract, can be umbrella contract and so on, and then you put the license on. One of the big problem I saw it because before we have many partners university they have no money. This is a big problem. But today, Voltage, we have money. So we have the money that we can see with the company, can we share? Or usually what I do also with university when I was in previous my job, I said, listen, we share 50-50. I know we have no money. I will take care to all
The administrative.
and everything. But when I license, especially with front payment, I must pay first myself. For example, I make la dépense for 1 million. Okay, 1 million, and we are receiving 10 millions. So I will take 1 million because at least, and then we have 9 millions to share, 4.5, 4.5. Okay, NDA, MOU contract, or sometimes if we are hurry and then we can go directly to the contract. Okay, but right now, as I told, we are working because we are working with VP Research together, and we have a community, and then we are working. I think when I come to Voltage, the first one is to make the strategy and the vision, and then you can see right now we have 2 IP guys, and Olivier his share it's 50% with the Concordia IP, Voltage, and Axelis. Okay, so and then of course there are ways that we can work with the government. We need to increase this team, hopefully about 12 to 14, because we need a team for license for transfer technology. Yes. Other questions?
For NDA, I would advise against having any mentions of like sharing IP. What you want to do is like just stating, don't want to be using the IP, licensing or exploiting any IP discussed during that NDA. Then you have a contract or a collaboration partnership contract. The NDA is just like okay, we have converging interests. Let's talk, find out and exchange details. Then we have a collaboration.
How do we sort out like the inventors, for example, if the project is a collaboration between, let's say, employees and.
Yeah, inventor, what she said is very touchy, but usually, okay, what we do, you should document it. This is the mistake, we should document it. And then, for example, if there's something there, can be assistant, we take minutes.
Yeah.
And then we can document it, okay? Especially in our case, I am author, I don't care because I receive 0. For 1,080, I receive 0. All my career I receive. But if I am in university, or if I am, maybe I am billionaire, I'm not here today, okay? So, especially when the money talks, you should be careful. So it's better that when for example, I work with the Sony and so on. Sony, they have the authorship and so on. They make everything by the minutes. This ID, for example, this one was done by this one. I believe you are right. You have already explained about the authorship. Authorship is very complicated. And then, if for example, I give ID with you and you never put my name, I can go to USA. And then I can invalidate all this patent. You spell billion on research, one person can invalidate all the patent. So you should be careful. I think the best way is always good relationship. But everything must be writing is the best way. When you have my answer, no, let's take the minutes. We should take minutes. This ID is by Beatrice, this ID is by Catherine. Me, I just watching, I never open my mouth. I never be authors. Okay.
You can also send the minutes to your partner
Yes.
afterwards.
Yes.
That's what we talked about.
Yes,
What
yes,
you think you want
yes,
to edit,
yes,
to like 24-hour window.
In order, this is, as I said before, say, no, it's not, we take the minute, we take everything, and then this is, it's very touchy, especially when is money, okay? We need to stop. Okay, we need to stop. But we are very open, as you said, we have experience, we can help the researcher, the professor, the industry, so thank you both of you, okay, merci beaucoup.
Thank you.